Later, I can see the time probably is getting of the essence, but I'm very grateful to the Honorable Deputy Minister, Honorable Ms. Lidwina Shapwa, and also my learned colleague Hassan Mulud, who said quite a number of things that I was going to say, which hopefully should make us then go quicker. They both refer to the African human rights system, and let me just add that in our context in Africa, we say the African human rights system exists at three levels. At the national level, at our regional level, which in UN terms we call the sub-regional level, and at the continental level. And as the Honorable Minister said, at the continental level, the core of the African human rights system consists of the African Commission on Human and People's Rights, which has both a promotional and a protective mandate. It consists of the African Court on Human and People's Rights, which exists to complement the Commission's protective mandate, and has the African Committee of Experts on the Rights and Welfare of the Child, which we sometimes call the Children's Committee, which focuses on the rights and welfare of the child. Mr. Moderator, it is important to note that the Commission, the African Commission for Human and People's Rights, which has both a promotion and protection mandate, has several special mechanisms, as does the UN, including rapporteurs, both on a geographic basis and a thematic basis, and working groups, both standing working groups and ad hoc groups. And that this system, the human rights system, is embedded in a larger ecosystem which we call the African governance architecture, which then has other parts of the African Union, including the Pan-African Parliament, including at the regional level, the regional economic communities. And that the African human rights system, as the Honorable Minister said, takes a very expansive view of human and people's rights and of what it calls a human rights instrument. So for instance, the African Court has found that our Charter on Democracy, Elections and Governance is a human rights instrument for Africa. Honorable Moderator, in terms of cooperation between the African human rights system and the UN human rights mechanisms, as Deputy Minister Shapwa said, the African Court, the African Commission, the African Children's Rights Committee frequently cite and implement instruments, legal instruments of the United Nations, standards, human rights standards of the United Nations, and the jurisprudence and the soft law of the several UN mechanisms. The African Commission and the Child Rights Committee also have a track record of cooperation and collaboration with their counterparts at the UN and also at the Office of the High Commissioner for Human Rights, just as the Honorable Deputy Minister said, and they do this through joint workshops, through joint missions, through joint reports, and through joint statements, such as the example given of the joint statement of the Special Rapporteurs on Freedom of Expression at the level of the UN, at the level of the OSCE, the Organization for Security and Cooperation in Europe, and their counterpart at the African Commission on Human and People's Rights. And I think the Honorable Minister also highlighted that the Office of the High Commissioner for Human Rights is a significant actor in capacity building on issues of human and people's rights at the three levels of the African human rights system, meaning they work with national governments, and there they work with all three arms of government, the executive, the legislature, the judiciary, the national human rights institutions, and they also work with civil society and with lawyers and lawyers associations at that level. And at the continental level, they have recently signed or renewed memoranda of understanding with the two key bodies, the Commission and the Court. I'd also just point out that the African Human Rights Court has also just recently signed a memorandum of understanding with its key counterparts. That's the European Court on Human Rights and the Inter-American Court on Human Rights. Honorable Moderator, with regard to Western Sahara, again, as has been pointed out by my colleague Miliud, Western Sahara is a party to the key human rights instruments of the African Union. It's a party to the African Charter on Human and People's Rights since 23rd May 1986, to the protocol to the African Charter establishing an African Court on Human and People's Rights since 27 January 2014. It is also a party to the African Union Convention for the Protection and Assistance of Internally Displaced Persons, our IDP Convention, since 27 January 2014, and also a party to the African Union Convention on Preventing and Combating Corruption, also since 2014, and the African Charter on Democracy, Elections, and Governance, also which it acceded to on 27 January 2014. It has signed, but it hasn't yet ratified, the Protocol on the Rights of Women in Africa, and we encourage it to do so. It has also signed, although it hasn't yet ratified, the Protocol on the Rights and Welfare of the Child, and we encourage it to do so. As has been pointed out, it has faithfully submitted its state reports under the African Charter on Human and People's Rights to the Commission in Banjul. Nonetheless, and I won't belabor the point, which the immediate former speaker, the Honorable Aminatou Haidar, said, grave human rights and humanitarian crisis persists. And we, as Africa, and as the world, as a community of nations, seem to be unable yet to decisively intervene to ensure sustainable resolution of this crisis, at least 45 years after they began. With regard to the Republic of Morocco, which, as you heard, was allowed by its sister states to rejoin the African Union in January 2017 without any preconditions whatsoever, regrettably, Morocco is not a party to any of the key human rights instruments of the continent. Not the Charter on Human and People's Rights, which every other state, including the youngest state, the Republic of South Sudan, already a charter. It's the only of the 55 states that's not a party to that charter, neither to its protocols on women's rights or on establishing the court, neither to the Charter on the Rights and Welfare of the Child, or the Convention for the Protection of Internally Displaced Persons, or combating corruption, or on democracy, elections, and governance. As has been pointed out, it has ignored and defied several decisions, several resolutions, and several recommendations of virtually every body in Africa. Decisions of the AU Assembly of Heads of State and Government with regard to Western Sahara, of the Executive Council of Ministers, of the Peace and Security Council of the African Union, of the African Commission on Human and People's Rights, of the Child Rights Committee on the issue of Western Sahara. And because it is not a party to the Charter or the protocol establishing the court, it cannot be held directly to account before them. In terms of some recent dynamics, and I think this has also been pointed out, the African Commission, at the direction of the Executive Council of Ministers, undertook a fact-finding mission to the people of Western Sahara, but it was not allowed to access significant parts of Western Sahara that are under the control of Morocco. Nonetheless, it produced a report with recommendations which went back to the policy organs of the African Union, the Executive Council of Ministers, and the Assembly of Heads of State and Government, who directed it to undertake a follow-up mission that it has not been able to successfully do, because the Kingdom of Morocco defies decisions, requests that it allows these AU bodies to access that territory. I think Honorable Minister spoke about the International Court of Justice. I think it's important to point out also that the Court of Justice of the European Union, which is many times called the European Court of Justice, has ruled on at least 3 occasions on the issue of Western Sahara, and has found that bilateral agreements that Morocco enters into with other parties including the European Union, with regard to the territory of Western Sahara, are unlawful, and that that policy cannot be allowed to continue. So at least one other international court in Europe has ruled definitively on the issue of Western Sahara. So what then do we do? As I said, we have the African human rights system, but that's embedded in a larger body, the African governance architecture. And the Pan-African Parliament was mentioned. And I would add that the Pan-African Parliament, like its sister institutions have tried to do, should undertake its own examination of the situation in Western Sahara, especially the defiance of lawful orders by organs and institutions of the African Union, and make more robust and wide-ranging recommendations or a call for action from the apex bodies of the African Union, that's the Assembly of Heads of State and the Council of Ministers. And these bodies should also activate their own mechanisms for sanctions for non-implementation of their decisions by a member state. And whereas the Kingdom of Morocco is not a party to the African Court, 30 states are. And that court can also issue advisory opinions like the International Court of Justice. And we urge that litigants consider moving to the African Court to get an advisory opinion on what are the obligations of the other member states of the African Union towards the citizens of Western Sahara. We also urge that there be more joint work between the special mechanisms of the African human rights system and of the UN human rights system on the crisis of Western Sahara, such as joint statements, petitions, fact-finding missions, and so on. And finally, to the citizens. At a time when our states seem unable to move robustly, we call for a new solidarity among African citizens and global citizens to take up the campaign for the human and people's rights of the people of Western Sahara more actively. Thank you very much for your attention, Mr. Chairman.